first case to come before the court is Michael Stanford v. Bruce Williams. Each party will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. But if you do plan to reserve time for rebuttal, please let me know because I'll be keeping track of time. And when you get to that point in your argument, I'll try to give you some notice that you're headed into the rebuttal time. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children or minors or victims, should that be relevant to your argument. You can refer to those folks by initials or general terms. We have read your briefs and we're ready to proceed when you are, so I would just ask the appellant at this time, would you like to reserve time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for my rebuttal, please.
Okay, very well. You may begin when you're ready.
Thank you, Your Honors. Good morning. Attorney Eric Hall on behalf of the appellant, Michael Stanford. This matter began when the appellant hired the appellee in this case, Attorney Bruce Williams, represented 2 criminal cases. One was an assault, one was a case involving falsification, and a civil protection order case. All of these matters were the result of the appellant's unfortunate encounter with a lady that he had originally hired to clean his home. The appellant was basically trying to help this lady who was down on her luck, and was told a story that she was down on her luck and needed assistance to get back on her feet. So the appellant, being a good-hearted person, tried to help out, plus he needed help cleaning the house. It's a single file. I want to point out for the record that throughout this matter, this was a strictly platonic relationship. There was never any romantic interest or involvement in this matter. The appellant, a good-natured person, allowed this lady to move into his home to help her out. She was down on her luck with no place to stay. And he allowed her to be an authorized user of one of his credit cards, only for the sole purpose to help build her credit. It's important to note that she was never allowed to use this card for personal use. She would have built her credit solely through the appellant's use of the card, and with her name being on it as an authorized user. The appellant, after a while, discovered that he had been tricked, that he had been used, and that this lady was using his card multiple times without his permission. This resulted in an incident where the appellant was going to sit down with this person, go through this. What happened was, before that happened, he had found out that she had moved out all her stuff on his home, caused damage, poured wax down the sink, knocked holes in the wall. The incident happened with the assault charges when she tried to return to the home and get back inside the appellant's house. He blocked her access. She tried to push, he charged him and tried to push through him. As a result, as she contacted the police, lied about the incident, and as a result, the appellant was charged with assault. Later, she filed for a civil protection order against him. The appellant, discovering the misuse of his credit card, reported that to the police. The police did a poor investigation. They didn't understand the use of these cards, Square, and some other things. They made a quick determination, an erroneous determination, and charged the appellant with falsification. What I want to tell the court is, afterward, after this lady had moved out, after all these things like that, the appellant learned that this person that he tried to help was a drug addict, a convicted thief, and was advertising prostitution services on
Counsel, I just want to make sure, is all of this in the record?
It is in the record. She was actually arrested. That's how I found out. It was actually online. I think Boardman police arrested her and charged her with prostitution, and at the time she also possessed heroin. That's how I found some of this out. In my appeal, one assignment of error, that the appellee representative, appellant hired the appellee as his attorney on all of these matters, on the civil protection order, on the assault case, the criminal case, and the criminal falsification case. One assignment of error, Your Honor, that appellee, which the trial court erred in granting judgment on the appellant's malpractice claims, granting in favor of the appellee, when the appellee breached civil protection order was granted. There were a couple of them filed. I believe the second one was filed. And Kelly told Mr. Stanford that he had enough evidence that he could go there on his own and represent himself. Which, of course, this court knows that pro se representation on something like this is probably a bad idea. Well, it was because the magistrate in that case granted protection. It's important to note in the magistrate court's decision of the bench trial that in making their decision, this is a quote from the decision, there is no dispute that an attorney-client relationship existed between Stanford and Attorney Williams, with respect to the criminal cases and the CSPOs at the trial court level. Quote, despite this finding, the magistrate's decision found that Attorney Williams, Attorney Williams consistently and erroneously states at the end, accordingly, this court does not find an attorney-client relationship existed between Attorney Williams and Stanford for the purpose of appealing the CSPO. This case, Your Honors, was never about an appeal. Okay? And this is certainly just for the record. I know the learned judges know this, but this court knows, and the Ohio Rules of Civil Procedure are clear, that before an appeal can be filed on objections, on a magistrate's decision, objections must first be filed. Usually you have a 14-day period to do that or to do something. That simply wasn't done in this case. The appellee did not file objections to the magistrate's decision. The appellee never advised the appellant regarding the necessity of filing objections to the magistrate's decision within the 14-day period. And that
I apologize, I got a little on the eyes, but I'm just wondering when the attorneys switched, and I know that the different attorneys hired or retained in order to pursue the appeal. But was that attorney retained during the time period that the objections would still be timely?
I believe there was still time, but the problem was, and there's a letter, and it's part of the record on this, where the letter basically states that Attorney Steek, I think that's correct pronunciation, was going to be handling this, but she was going to be working with the appellee, Attorney Williams, on this, the final appeal. And there was actually a meeting to introduce Mr. Stanford, the appellant, to Attorney Steek. Once again, no advice from the appellee that, look, we have to file objections on this. He was basically kicked over to Attorney Steek for the purpose of filing an appeal.
And counsel, where can we find evidence in the record of who paid for the transcripts that were ordered, or who ordered the transcripts?
The appellee, Attorney Williams, ordered the transcript. He did order a transcript. So he was aware.
Where do we find that in the record?
I believe it's in the deposition, and I believe it was also in the trial, at the bench trial. He did order a transcript, so he knew something had to be done, but never filed the objections. And as this court was aware, an appeal was filed, and that subsequently filed appeal was doomed from the start, because the court would not exercise jurisdiction over the appeal, because they couldn't as a matter of law, because objections had not been filed, and there was no rule for the court on the objections were filed. But what I would tell the court is this: despite what the appellees argue, this is a garden variety legal malpractice. It's akin to failing to file a complaint within the statute of limitations, missing one of the statute of limitations, failing to timely file an appeal or final appeal, or any other legal failure that would obviate a client's right to challenge an adverse decision from a court for a seeking redress. That's what happened in this case. He just didn't have the opportunity.
What do you agree that we have to look at case within case?
I'm sorry, Your Honor.
Do you agree that we have to look at the prejudice case within case?
Well, I would agree to some extent, but here's the problem with this, Your Honor. The appellees would argue that the appeal on the protection order would have failed. I think that's the argument. But There was never objections filed to the magistrate's decision, so we don't know how the trial court would have ruled on the magistrate's decision. So we never reached that level of a case within a case. I would agree it's a better argument if the case would have proceeded correctly to the appellate court. That did not happen. So,
As an appellate court in reviewing the magistrate's decision, or we also are not reviewing the magistrate's decision, but the trial court's decision based on the magistrate's decision. Do you know if there was ever an issue raised of plain error or was it a legal issue?
I'm sorry. I'm hard of hearing myself. I would have been tracking.
I just don't want to ask everybody sitting here and waiting for us to get it. What I was wondering is if this issue was talked about at trial court level, okay, and that issue is even if you don't file objections, you can still argue plain error or you can argue legal issues.
I don't believe that was done. I believe that this appeal was, for lack of better words, was not properly prepared from many levels. Of course, it was an appeal that should have never been filed, obviously. But in reading that appeal, it did not look at a lot of time.
Counsel, I'm going to let you know you have moved into your rebuttal time.
I'm sorry.
You have moved into your rebuttal time. You're at almost 4 minutes.
I'm sorry. I will conclude and I will save my 5 minutes for the vote.
Good morning. May it please the court, counsel. My name is Brian Sullivan, and I have the pleasure of representing Attorney Bruce Williams in this appeal. I urge this court to affirm the order of the trial court adopting the magistrate's decision that Mr. Williams was not liable for legal malpractice for 2 reasons. First, the trial court did not abuse its discretion in independently reviewing the matter and concluding that the magistrate properly determined the factual issues and appropriately applied the law. And 2, there was sufficient evidence presented at trial establishing that Mr. Williams did not breach the duty of care when he recommended Mr. Stanford accept the plea on a reduced charge, and when he referred the post-civil protective order matter to another attorney for handling. I think it's important to recognize that this court's standard of review is one of abuse of discretion. This matter was heard before a magistrate in a civil trial, as a bench trial. The magistrate was a finder of fact, made findings of fact and some conclusions of law. Those findings of fact were supported by competent lay testimony as well as competent expert testimony. Objections to those findings of fact and conclusions of law were made to the trial court. The trial court independently reviewed the record, analyzed the objections and assessed them, and ultimately concluded that the magistrate properly discharged his duties in resolving factual issues and appropriately applying the law. The question here is whether the trial court abused its discretion in conducting that independent review and rejecting the objections that had been filed. As this court well knows, an abuse of discretion standard is very deferential, and it requires a finding or conclusion that not only was the trial court's decision wrong, but that it was unreasonable or arbitrary or capricious.
Counsel, were there objections that were raised that were going to more to the factual disputes?
As it related to the attempted appeal from the civil protective order, there were no objections that were filed. I don't recall what the specific basis was for the arguments that were raised on appeal of that, but I do know that the appellate court dismissed that appeal, finding a lack of final appeal of the Lord because of the failure to assert objections.
So just out of curiosity, was it dismissed or was it affirmed based on the opinion prosecution of the record?
My understanding is that the appeal was dismissed.
Okay, interesting. But what I'm saying is in this particular case that we have in front of us today, did they file any objections that related to factual matters?
They did not, Your Honor. No objections were filed to the order granted the civil protective order. And you had asked a question of Mr. Hall in terms of when was the retention of the second attorney? Was that prior to the expiration of the time to file objections? And the answer to that question is yes, it was. The civil protective order was issued on October 14 of 2016. Upon receipt of that order, Mr. Williams arranged for a meeting with Mr. Stanford and the new lawyer, Ms. Stitch. That meeting resulted in Ms. Stitch executing or sending a retention agreement. That retention agreement was dated October 27 of 2016, which was 13 days after the entry of the order granting the civil protective order. So Ms. Stitch was retained prior to the expiration of the time within which to file an appeal.
So one day.
One day, she testified at trial that she was mistaken in her belief that she thought that the civil protective order had been issued by a judge, and that then as a consequence, that is why she filed the appeal as opposed to filing an objection.
But counsel, the need to file the objections, was that really part of the appeal, or was that part of the work in the trial court?
Well, it was part of the responsibilities of Ms. Stitch in her representation of Mr. Stanford.
But Ms. Stitch was, according to what I think I read in your brief, was hired for the purpose of appeal, correct?
Yes, for handling the matter after the issuance of the civil protective order. The retention agreements that were executed by Mr. Williams clearly delineated the scope of his responsibilities, and it was for pre-trial
Let's talk
representation.
about that for a moment, because I also noted that in your argument. Did the retention letter actually say that he doesn't handle appeals, or did it say something about the retainer not being applicable to an appeal?
My recollection is that the retention agreement was specific in including the fact that he only represented the defendant in pre-trial proceedings, and that did not include trial proceedings or appeals. And Mr. Williams testified at trial that in fact is his position, that he was only representing Mr. Williams for purposes of handling the civil protective order, and that he had no involvement in representing him after the civil protective order had been put in place.
But wouldn't objections, what about opposing counsel's argument that if objections had been raised, there might not have been a need for an appeal?
That was within the purview of Ms. Stitch's responsibility in representing Mr. Stanford going forward. And she testified that she made a mistake in her assessment of what the order was and how she handled it. Mr. Williams had no role in obviously filing objections, because no objections were filed. He did not draft the notice of appeal. He was not on the briefs. He did not participate in any of the appellate proceedings. It's not what he does. He was retained to represent Mr. Stanford for the pretrial proceedings in both the civil protective order matter as well as the assault and falsification matters, and that's what he did. It's also important to note, Judge Carr, you asked about the case within the case doctrine, whether or not the plaintiff was successful in presenting evidence in his malpractice claim against Mr. Williams that either objections or appeal of the civil protective order would have been successful. There was no evidence presented at trial that objections or the appeal would have been successful. In fact, there was evidence to the contrary. Mr. Stanford's expert acknowledged that he had no criticisms of the trial court's granting of the civil protective order, didn't have any opinions about any legal errors that were issued when that civil protective order was issued. And Mr. Nathan, an expert retained by my client, testified that in his opinion, it was highly unlikely that Mr. Stanford would have gotten relief through an objection or an appellate remedy. And as this court recognized in Davey versus O'Brien, a plaintiff is required to satisfy the case within the case doctrine to substantiate the claim for legal malpractice. And in the trial of this legal malpractice claim, there was zero evidence establishing that Mr. Stanford would have been successful in challenging the civil protective order.
Counsel, I have questions that I need to ask before we get to run out of time here. The second attorney, did she file an appearance at the trial court level?
My recollection is that she filed a notice of appeal of the civil protective order.
Right, I understand that, and I'm trying to figure out, did she file a notice of appearance in the trial court?
Not that I recall, Your Honor.
The other thing is, did appellant withdraw his counsel in the trial court?
No, Your Honor.
And then I have one more last question, and that is, with the trial court, when it ruled on this, I think the opposing counsel mentioned it, and that was a trial court said that looked at it as an appeal, malpractice appeal. If we determine it's not a malpractice appeal, but the alleged malpractice happened at the trial court level within the objections process, would that mean we should send it back to the trial court for them to look at and do in the way that we should be looking at this as possibly malpractice at the trial court level?
I don't believe so, Your Honor. My position would be that the plaintiff's malpractice claim fails, and that the trial court below, the trial court here, appropriately discharged its duties in reviewing the magistrate's findings and conclusions of law. And in doing that, they determined that there was sufficient evidence to support the magistrate's findings of fact, and that the magistrate appropriately applied the law to those facts and come to a conclusion. And that there is no, plaintiff hasn't even advanced an argument that the trial court's decision below, here, the trial court decision here, was arbitrary or reasonable, or that the trial court somehow, in some manner, abused its discretion. My perspective is the bottom line is there's an issue of fact, of disputed fact, between the parties in terms of what happened and the consequences of what happened. Those issues of fact were tried. The magistrate, as a finder of fact, weighed the evidence, assessed the credibility, reviewed the information that was presented, and made findings that Mr. Williams did not breach a duty of care to his client, and that the attorney-client relationship terminated when Mrs. Stitch was retained to represent Mr. Stanford going forward. I fear that I've lost track of my time.
You have 5 minutes and 10 seconds.
Wonderful. With the court's indulgence, then I'd like to address the other component of plaintiff's claim, and that is the allegation of malpractice against Mr. Williams for recommending that Mr. Stanford accept a plea of the assault and falsification charges. And although Mr. Hall didn't have time to address that in his opening remarks, it certainly was a focus of the arguments raised in the brief. And I would respond to those arguments by submitting that there was sufficient evidence submitted to the magistrate demonstrating that Mr. Williams did not breach a duty of care in recommending the plea be accepted by Mr. Stanford. Mr. Stanford made clear to Mr. Williams, and this was testified to during the course of the trial, that he wanted to avoid jail time for the criminal charges that were asserted against him. Mr. Stanford has complained, and the basis of his complaint here is that Mr. Williams should have recommended that he not accept the plea and take his chances at trial. Because if he took his chances at trial, there was a potential that the victim would not appear at trial and the prosecutor and the court would dismiss the criminal charges. There was testimony presented below by the defendant's expert that was unreasonable to expect that the victim would not show up to testify in support of the assault or falsification charges. She had appeared in other proceedings against Mr. Stanford. And although there was, Mr. Hall had mentioned that there was information that this victim also had a criminal record and that may result in her being reluctant to show up for the court proceeding, the fact of the matter is she had appeared in other court proceedings. It's also important to note that there were 2 independent witnesses besides the victim who were prepared to testify in support of the assault and falsification charges. It's also important to note that the falsification charge did not require the testimony of the victim to support that. That charge was leveled as a consequence of the allegation that Mr. Stanford misrepresented or lied to the police officer when he reported that the victim was not an authorized user on his credit account, when in fact she was. Now there was a dispute as to the scope of her authorization, but Mr. Stanford represented to the police that she was not an authorized user on the account, when in fact she was. That form of predicate for the falsification claim, the victim's testimony is not relevant to establishing that. It's also important to note that Mr. Stanford's father also thought accepting the plea was reasonable. The plea itself, the offer of the plea itself was good by the evidence in the record. The prosecutor who was pursuing the charges had a reputation for being a tough prosecutor. The fact that she was willing to negotiate 2 M1s down to 1 M4 and avoid jail time weighed in favor of accepting the plea. There was also evidence that in order to successfully dispute the falsification charge, an expert should be retained to assist in the defense of that. And the cost of retaining that expert was about $10,000, which Mr. Stanford either wasn't in a position to or wasn't willing to pay. And so the point being that plaintiff's argument as it relates to this specific criticism ignores the evidence in the record which demonstrates or which sufficiently establishes adequate support for the magistrate's conclusion that Mr. Williams did not reach a standard of care. Unless there are further questions, I would urge the court to affirm the trial court's adoption of the magistrate's decision in all regards.
Hearing none, thank you, counsel.
Thank you.
Hey, counsel, you'll have just over 4 minutes for rebuttal.
I'm going to have in mind, I'm going to try to be as succinct as possible. I'm going to briefly address the criminal charges in this case. In Applebee's, counsel used the word highly unlikely. In this case, the alleged victim in these matters, it was highly unlikely at the point that these matters would have brought the trial to a case. She may have previously appeared on different hearings, which is civil protection, where obviously she appeared with that. But by the time these things were getting to the point of pre-trial trial, the police sheriff's department could not find her. She had a warrant, and also the arrest, more than an arrest, that came out online. The arrested for offering prostitution services online, which an undercover officer, that was an arrest for an undercover officer, confronted her in the hallway of her apartment, and she basically told everybody, "We need your services," and also she was arrested. She had heroin in her possession. So it was highly unlikely that in those circumstances she would show up for anything, Your Honor.
Counsel, did they need her for the falsification charge?
The falsification charge, Your Honor, the reason that appellant Mr. Stanford did not challenge that was that he was told incredibly that it would cost $10,000 to get an expert to defend or appear before this falsification charge, which all this involved was showing how the square app worked and how the cards worked. You could have gotten somebody, quite frankly, from a bank could have showed you that, and it would not have taken anywhere near $10,000. It didn't require that level of expertise on this. In this case, the decision of entrance decision is a flawed decision because it's so inconsistent at the beginning. He says that there's no dispute that an attorney-client relationship exists between Stanford and attorney was at the trial court level. But then he goes on to say at the end that for the purposes of appealing the civil protection order, there was no client relationship. This was never about an appeal. The appellee has tried to shift blame throughout this case to attorney Steve, basically saying that she was responsible once he introduced the appellant to attorney Steve. He further stated in his deposition, I believe, that he did not do appeals or objections. However, he also clearly testified, and this is in the deposition, that 40% of his practice was devoted to domestic or divorce law. Well, this court is well aware that almost every decision that comes out of that court is a magistrate's decision, which would require objection to the counsel. If you're practicing domestic relations law and you don't handle objections, that would be an unusual practice. You would literally have to cut bait every time a decision comes out and tell your client who's retained you, "I'm sorry, but you're going to have to find somebody else to do this because it's an objection," which is at the beginning of the case. To temporary orders on any case, it's going to be a magistrate's decision. If you don't agree with it, you're going to file objections to it. So that statement in and of itself is incredible. It was done to avoid responsibilities case. Another matter is that the attorney-client relationship was never terminated.
was it terminated?
I'm sorry.
How was it terminated?
Mr. Stanford terminated it. He sent him a letter on November 1st, 1 year later, November 1st, 2017, indicating that he no longer wished him to represent him, and he was terminating the relationship at the close of business that day. So it was the appellant who terminated the relationship. No letter of disengagement. In fact, the letter that's important in this case, and this court's aware that words have that meaning, where Attorney Steek says that she will be working together with the appellee. It doesn't say, and there's nothing that says from here on out, I will be your attorney, and there's nothing in the record that shows that the appellee sent something to the appellant saying, I will no longer be representing you, I'm terminating my relationship this time, good luck with your matters. Nothing in the record.
Counsel, you're almost out of time, but I want to ask you one question that I'd like some clarification on. Did Mr. Stanford pay Attorney Williams an additional $2,500 to challenge the stalking civil protection order, or was that part of the fee agreement as well?
He paid, Your Honor, it's somewhat confusing. He paid the appellee for representation in the assault case and the falsification case. Both cases he's represented. It's clear that he was representing Mr. Stanford in those cases. Also, the civil protection order case, which the court correctly points out, is always the trial court level. It's never an appeal until there is the court's ruling on objections that have been timely filed on the magistrate's decision, which simply wasn't done. As I indicated before, I'm asking the court to reverse the court's decision. It's garden variety malpractice.
Okay, we need to wrap up.
Thank you, Your Honor. Thank you.
Thank you. Thank you both for your presentations. The court will take the issue under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both again for your presentation.
Thank you.